Good afternoon, everyone. I'm David Stock and I'll be your moderator today. Thank you for attending today's Wolters Kluwer CCH Networks webinar. The goal for CCH Networks is to share the latest information with you, and today we will be outlining the outcome of the full federal court decision on Chevron. We'll be using GoToWebinar to run through today's session, and many of you will be familiar with this software, but for those of you who are new to the experience, we'll just quickly run through how it all works. This is the GoToWebinar window, and on the right-hand side, you'll see your control panel. Let's take a closer look at the controls. You can use your orange arrow to minimize the control panel and reopen it. We suggest you join using your computer audio option. Alternatively, if you prefer to dial in, select a phone call and follow the dial-in information, including the audio pin. You can submit questions at any time during the presentation by typing your questions into the questions pane and clicking send. We will collect those questions up and ask them at the end of the presentation during our Q&A session. We'll attempt to answer as many questions as we can in the time available, but we obviously need to work within certain time constraints today, and we will take any questions that remain unanswered offline and respond via email after the session. The deck from today's presentation will be circulated along with a link to the recording by close of business today. We're privileged today to have the lead lawyers on both sides of the Chevron case presenting for us. Michael Clough, partner at King & Wood Mallesons, acting for Chevron, and Chris Kinsella, partner at Minter Ellison, acting for the ATO. This is a unique opportunity for us to hear their considerable expertise in stepping us through the decision so shortly after the full federal court judgment. We're also very pleased to welcome Paul Sapri, Assistant Director, Corporate Tax Association, as our facilitator, and delighted to have the CTA involvement today. Michelle Denise, Executive Director, is in Perth for a CTA meeting, and she is connecting to the webinar with the CTA Perth group. Thank you all for joining us today, and we will circulate the slides after the webinar. I'll hand things over to our presenters.
Well, it's Chris Kinsella speaking. Good afternoon to those on the East Coast, good morning to those on the West Coast, and hello to anybody who's anywhere else. I'm told there's 625 registrations for this webinar, so that has to be, I think, for both Michael and myself, a record in terms of number of people we're talking to. You will see in the slides an index of a dozen topics that we wanted to address in the time that we have with you. And without further ado, we will move into those topics. The first slide is a structure diagram. Some of you may have seen that before. It's fairly self-evident. The only point we wish to make on that is that if people could note that CFC, Chevron Finance Corporation, is a subsidiary of CAHPL, Chevron Australia Holdings Proprietary Limited, which in turn is a wholly owned subsidiary of CPX, being Chevron in the US, the oil and gas super major. And the funding arrangements are set out on that slide, and we don't propose to go through those again. Moving on to slide 2. So what we have on the 21st of April, a 64-page judgment handed down that adds to the law that we received in October 2015, where we received a 206-page decision. This decision was a decision of the full federal court, Justices Allsop, Pagone and Perram, two separate decisions delivered. Justice Pagone wrote the main decision, just saying that the interest in this Chevron decision is because it provides some much needed judicial guidance on how we interpret the transfer pricing provisions in the Income Tax Act, and in particular guidance on arm's length consideration. But on this first topic of the interplay between statutory interpretation and commercial reality, right from the get-go of the full federal court decision, we see Chief Justice Allsop in particular stressing that it is paramount to recognise the fiscal and commercial context in which these transfer pricing provisions operate. And on the next slide, you will see some comments down there, some important comments that inform the whole approach to transfer pricing. So he said, as we put on the slide there, the focus is to bring a commercial reality based on a hypothesis of actors independent of each other in circumstances where that commercial reality has been distorted by considerations that can be described as a lack of relational independence. The provision should not be interpreted pedantically. They should be given the necessary flexibility of analysis in applying the statute to the infinite variety of circumstances of commercial life. And there's similar comments by Justice Pagone further on in the judgment. And throughout these slides, you will see that Michael and I have inserted references to particular paragraphs of the decision. So if you're so minded, you don't need to read all 64 pages. You can just go to the highlighted paragraphs in these slides. So what are the implications of that? The opening, one of the initial questions coming out of this decision is that one could say that the full federal court in some respects has gone further than the trial judge in relation to this question of how you interpret the transfer pricing provisions. So the full federal court has said, and Justice Robertson said, you must have regard to the particular words of the statute. That is very, very important. But the full federal court has come out and said you must have a commercial overlay to that, and that comes through in those quotes we gave before. So, so that lens and those comments are an interesting observation and will inform transfer pricing analysis going forward. Michael, I don't know if there's anything you wanted to add.
I think it's fair to say that probably brings to a head what will ultimately be the difference between the Commissioner and taxpayers. The Chief highlights very clearly that the problem that he had with price the transaction as was is that it's open to manipulation of the structural features to achieve a presumably tax-driven outcome, and i.e. tinker with the terms of the loan to achieve a higher interest rate. So, so that's what the Chief perceived to be what Division 13 was about. There's a danger in that, of course, in that the Chief may be right or wrong. Obviously, the full court thinks he's right, but the High Court on occasions keeps warning us, in construing a statute, it is not for a court to construct its own idea of the desirable policy, impute to the legislature and then characterise it as a statutory purpose. The statutory purpose is only to be derived from the words and the consideration of legislation as a whole. I might say in why we differ and why this case has run so long and so hard is that is the fundamental difference. And I read from the original 1979 OECD report, which was the foundation of the guidelines and which, until the very recent BEPS changes, I think has remained unchanged as a matter of principle. In general, the approach which is adopted in this report to the adjustment of transfer prices for tax purposes is to recognise the actual transactions and the starting point for the tax assessment, and not other than in exceptional cases to disregard them or substitute them for other transactions. The aim is, in short, for tax purposes, to adjust the price for the actual transaction to the arm's length price. And then it goes on and has a whole section on loans and says, ideally in each case, the real point of distinction on this in this case so far has been whether or not the statutory interpretation by reference to the policy perceived by the Chief Justice and ultimately by the court, the full court at least. I don't think the trial judge went down this track. In fact, the trial judge deliberately avoided getting into this debate give us that guidance, and that's what full courts are expected to do. And the full court has come down on the basis that it's very much a par for a type approach, and whereas the taxpayers' principal arguments are that par for a is the par for a with the way it goes about constructing hypothetical transactions that are designed for tax purposes, and that more akin to the OECD reporting guidelines, the actual transaction to be priced is indeed that, the actual transaction, and that all that the case should be about is looking at the consideration that was given in the actual transaction and seeing whether or not that should be varied. So I think we can move on to the next slide after what really is, I think, the statutory background.
Yeah, so moving on, we're on slide 3 now, the orphan theory, and those of you old enough might remember that old black and white movie of Oliver Twist. Justice Robinson and the full federal court held that Capel was not an orphan. That is, Capel was not to be assessed as a standalone entity shorn of all affiliation, not only to the lender, its subsidiary lender, but also shorn of affiliation to its ultimate parent. And Justice Pagone said, in effect, that so to do would distort the application of Division 13 and fundamentally undermine its purpose of substituting as a comparable a real-world arm's length consideration. Chief Justice Allsop made similar comments. So why was this important? Because Chevron in the US is and was a double-rated oil and gas super major, and Capel's independent credit rating was far removed from that, many notches down. So the result of that is that Chevron in the US could and did borrow at a substantially lower cost of funds. So this orphan theory, and the Commissioner had an alternate theory, which you don't see come through in the decision as such, but we called it the identical twins theory. At its simplest, you assume that Capel is, say, wholly owned by an oil and gas super major like Exxon or something, and you assumed that CFC, the lender, is wholly owned by an oil and gas super major like Shell, for example. We have put in there is an interesting question that comes up with the orphan theory, not on the facts of this Chevron case, but what if the loan had been from Chevron US, the parent, rather than from CFC? How would it work then? In saying that the nexus, the relationship between borrower and lender is broken, the debate about orphan theory comes to the fore in circumstances where the lender is not the parent. But in circumstances where the lender is the parent, questions whether the orphan theory could be invoked there. It's an academic question because it wasn't the case on the facts in question here. So the orphan theory, comments on the orphan theory, standalone, permeate right through the full federal court decision, and they permeate for many of the other conclusions. So that's why Michael and I put items 2 and 3 up front, because they are an undercurrent, the building block to both Justice Pagone and Chief Justice Allsop's decisions. So, Michael, was there anything you wanted to add on?
Yeah, I will say here is where Justice Pagone's reasons seem to depart in their analysis from that from the Chief. And given that everyone agreed with Pagone, I suppose we should focus on his analysis. this comes back to what I call the par for analysis, in that Justice Pagone said of paragraph 131, the inquiry was not to determine the price of a loan which Chevron Australia obtained from its CFC subsidiary, and nor to price a loan which Chevron Australia, with its creditworthiness, might have been able to obtain as an independent arm's length party to such a loan. I'll stop there and saying I would have thought that was the test. But to make a prediction about what might reasonably be expected to be given or agreed to be given under a hypothetical agreement if the parties had been independent and were dealing at arm's length in relation to the acquisition. So I read that as an invocation of a par for a counterfactual, and as opposed to what at least Chevron have put forward, and I think is generally taxpayers' views, that one looks at the borrowing by the Australian subsidiary in this case and seeks to price that loan on the basis that it's borrowing independently. I might say that the orphan theory is an interesting point of disagreement. You'll see in the judgment that the Chief Justice distinguishes and to some extent disagrees with the full court in SNF on this point. It's often referred to as how many arms did you sever, and that to me seems to be quite a degree of tension between the reasoning of full court in SNF and the reasoning of the full court in this case. The full court preferring to adopt the reasonable hypothetical alternative approach, whereas SNF probably stayed closer to the traditional, what I'll call OECD approach.
All right, so moving on, we're on to topic 4, the lack of covenants and security. So a primary argument for Capel was that the lack of covenants and security in the particular credit facility in question was a key term of that particular contract, that property. It wasn't an aspect of consideration, and it supported the higher interest rate that was charged. So in essence, take the facility in question and price that facility. That is the statutory test, and that is particularly clear from Division 13, is the essence of the argument. Well, at first instance, Justice Robinson disagreed with that. So did the full federal court. And as mentioned there, Justice Pagone held the evidence before and found by His Honour amply supported His Honour's prediction of a reasonable expectation of borrowing by Capel being supported by security. Now, there was a question, and it's addressed at paragraph 37 of the judgment, about whether Capel even had the ability to give security that the court were inferring here. But again, I think that was sidestepped by the full federal court, and Chief Justice Allsop said on the evidence here, the covenant's absence was not dictated by any commercial or operational imperatives. Rather, their absence can be explained by the protection given to the lender by common control. Likewise, the absence of security given by Capel or the absence of a parent company guarantee can be explained by a lack of commercial or legal capacity for the former and intra-group choice for the latter. You see this commercial reality overlay permeating through into comments like that. So they are saying lack of covenants and security can be explained by the bigger picture, not by, and one has to have regard to that bigger picture. So, so that was a key. Those were key findings. First instance dealt with that in quite some detail, and possibly not as much detail in the full federal court decision, but Michael,
yeah, this is a much more difficult matter of statutory interpretation, and you can see that with the various reasons handed down by the trial judge and the full court, that there is a different approach to this at times. Essentially what it boils down to is, in the context of a loan, taxpayers' submissions are that all the rights and benefits and privileges under the loan agreement is the identified properties. And then you look at what consideration was given for those rights, benefits and privileges, and then you determine whether or not that was an arm's length consideration. The way the full court went about the task was to some extent, the same as the trial judge in this respect. They said that consideration was wide enough to catch more than the interest rate, which I guess must be acknowledged, because if a loan had a covenant to do something else other than pay interest, then that would be caught as well. But then went on to say that it could catch security, as the trial judge found, and the full court agreed, and that arm's length consideration should therefore be security, even though no security was offered. And again, the fundamental difference between the two submissions, with which, and obviously the full court took the Commission's submissions on this point, was that the loan is the use, the property under Division 13 is the use of the money for a period of time, whether or not it also has to grant security or not is a feature of the use of the money, whether it's constrained, and all the other covenants that might come into it. And one of the things that we are troubled by is, where do you stop when you come to wanting to reevaluate the loan? The trial judge, I think, wanted to stop at security because on the evidence he thought that that was a good idea, that commercially that might have been a good idea. The full court seems to go much further on this counterfactual and say that it could apply on the evidence to just about any term of the loan. So I guess my question is, well, the price of 7-day paper, which was the actual external borrowing by the subsidiary, would be quite different from the pricing of a 5-year loan, which would be quite different from the pricing of a 10-year loan. So, and the pricing of a loan with negative covenants would be quite different. The pricing of a loan with actual security would be quite different. The pricing of a loan with change of control provisions might be different. So I guess our question is, we don't quite understand that if you vary from the words of the OECD, why we suddenly pick one and not the other. And the answer to the trial judge was, well, it's all to do with the evidence. The answer in the full court was, on the evidence, it appears to be what would be the reasonable hypothesis of the transaction which would have been entered into, not the terms.
I think another point that is worth making here is that this is one area where the three decisions we have vary a little. So Justice Robinson at first instance referred to operational and financial covenants and security. I think from memory it might have been in paragraph 87 of his decision, but made no reference to guarantees. So he looked for presence of covenants and security. On the other hand, Chief Justice Allsop, as we'll see when we come to the next section, spent a bit of time on guarantees and felt that guarantee would have existed in his commercial reality world. And Justice Pagone seems to gives an impression that both would have existed. So the comments diverge a little bit between the judges in relation to the hypothetical transaction. So moving on to the question of the hypothetical transaction, the real transaction was such that CFC did have a guarantee from CBX and Capital did not. And the question then was whether a guarantee should have been assumed into the hypothetical transaction. And the full federal court spent considerably more time on this than Justice Robinson did. I haven't done a word search, but I'm not even sure if there was a mention of guarantee in the whole 206 pages of Justice Robinson's decision. But did get ventilated on appeal, and the impression I got anyway was that the judges were more prepared to look at the right-hand side of the structure diagram you have in your packs than possibly Justice Robinson was. They were prepared to have a look and say, well, what if you're looking into the real world, what did happen in the real world? So there's a quote in there in the slide pack from Chief Justice Allsop: the consideration that might reasonably be expected to be given by a company in the position of a taxpayer, Capital, would be an interest rate hypothesised on the giving of a guarantee of Capital's obligations to the lender by a parent such as Chevron. And then there's a very long paragraph from Justice Pagone at 133 that deals with guarantees. And of course, the question is, if a guarantee is to be assumed into the hypothetical, then should a guarantee fee be assumed into the hypothetical? And in circumstances here where CFC, although it received a guarantee, it did not pay a guarantee fee. Well, on that question of a guarantee fee, Justice Pagone said, and it's not on your in your slide pack, but it's also out of that lengthy paragraph 133. Justice Pagone said, there is force in the proposition that a cross-border guarantee by the United States parent for the benefit of the Australian subsidiary to raise funds in the United States market with the benefit of a guarantee from the United States parent might have attracted a fee from Capital to CBX. It seems to me anyway, and I'm sure Michael would agree with this, that there is some logic to, if you are going to infer, and this is me saying this is not the ATO saying this, I should say, but if you are going to infer a guarantee into an arrangement, then it would seem reasonable to infer a guarantee fee. There was, people may be aware, there was actually a case in Canada, the GE Canada case, that dealt with the pricing of guarantee fees. However, the full federal court didn't need to go too far down the track here because, as I said before, CFC did not pay a guarantee fee, and there was, according to Justice Pagone, there was just insufficient evidence to support the payment of a guarantee fee in this case. So that's where we stand on that.
Make a couple of points. First of all, working backwards from that comment, it's not surprising there wasn't any evidence of the guarantee fee or insufficient evidence of guarantee before the full court, and that was because the trial judge found that the consideration in question was the giving of security by the taxpayer, by Capital, not by a third party. And secondly, the notice of contention that the Commissioner filed in the Federal Court didn't challenge any of those findings and sought to argue that the guarantee analogy by submission on appeal without. So it's not surprising that the trial judge has made no findings on the guarantee because he found to the contrary. He found that the consideration was something else. So the full court, without dealing with that point, seems to have sidestepped that issue altogether. Excuse me. But moving to the guarantee point, we just say really highlights the danger of seeking to apply Part 4A type analogies to Division 13. If you go back when you see the structure, the perceived tax avoidance here, the elephant in the room, except in the Chief Justice's reasons, where the elephant was stomping around all over the judgment, was that the Chevron Australia subsidiary, Chevron Australia paid interest to a wholly owned subsidiary, which was US incorporated, received a tax deduction for that, but because of the difference in the cash interest rates, received tax-free dividends back under 23AJ. And I think during the course of the appeal, the Chief Justice referred to that as water into wine, and that was perceived as the tax avoidance involved. Well, there's one thing that always bemused me in this case is that the reason why there's no tax paid in the United States on any interest paid by most US subsidiaries to its parent is because the US parent is taxed on the worldwide income of the group. So if you look at that diagram again, all of it is in the US tax return. So it's not surprising that the actual interest payment is either ignored for tax purposes in the US or alternatively cancels out, because all the income of the Australian operations, from, in this case from the North West Shelf, is subject to US tax. So to take the classic example that Chris quoted a little earlier, if Chevron US simply lent money to Chevron Australia, it would never be subject to US tax, the interest income, full stop. And it would never be subject to a deduction in the US either. It only ever has one tax effect in Australia, and that's the tax deduction, can be interest withholding tax. In the US, the actual interest has no tax consequence. But that's because if you look at the $100 pie that Chevron Australia has earned from the North West Shelf, it's fully subject to tax in the United States. So whether or not $10 of it gets taxed as interest income and $10 gets a deduction in the US doesn't provide any further analysis of it. All the income of the Chevron Group is always subject to tax in the US. So really what it comes down to is what's the price? It's got nothing to do with tax avoidance. So consequently, when you get to these sorts of issues of guarantee, you ask yourself the question, first of all, what are the arms you have to cut off? And secondly, as Justice Pagone commented, if you put in a guarantee, then you probably have to put in a guarantee fee. And given that the difference in the rates is likely to be the difference between a guaranteed rate and an unguaranteed rate, we're not sure it progresses the transaction very far.
I could actually say more on that, but I'm getting looks from some of our Wolters Kluwer's friends here to keep it moving. So we will do that. Let's move to topic 6, the meaning of property. And I have to say some of these topics overlay with one another, but this was a very big issue at first instance, and it was a big issue on appeal. So what happened? You would have thought this was obvious, wouldn't you, when you have a loan, what the property is. The Commissioner said, well, if I get a loan, I get money, and it was USD that moved between the bank accounts of CFC and Capital, and Capital said, no, that's nonsense. It's the rights and obligations that come with the facility, and it's an unsecured facility. This is important because it impacts pricing. What moved was USD. What the loan agreement was expressed to be in was AUD. At the time, this back pattern was 2003 to 2008. At the time, there's a big difference between AUD LIBOR and USD LIBOR. USD LIBOR much lower, much lower. So Justice Robinson at first instance said the property was the rights or benefits granted or conferred under the credit facility, including the sums lent, which in some respects wasn't all that helpful because that sounded like the two things that referred to that were in question. But he did make it clear throughout his decision that he thought the loan agreement was in AUD, therefore it's AUD. So this is an issue that Capel won on. Now, Justice Allsop in the commercial reality world said what is property may involve a process of characterization governed by the definition of the terms, the commercial context, and the requirement to hypothesize what might reasonably be expected to have been given or agreed to be given, assuming independent parties. So again, he's coming back to commercial context. That paragraph, it's not in your slides, but it's paragraph 15 if you're interested. Justice Pagone said the property has all the rights and benefits granted or conferred under the agreement, including but not limited to the amounts received by way of loan. That sounds like what Justice Robinson said, so it's AUD, but he did say the absence of security and covenants was not part of the property that was acquired, but it was more an absence of consideration. So as you'll see on the next slide, this what sounds like an academic discussion really feeds into it was important on the facts of this matter because of AUD and USD. So you see the last quote on that slide that has that old Australian dollar bill that many of us haven't seen in a long, long time. The evidence, however, was capable of supporting a different reasonable expectation because the funds lent by CFC to Capel were wholly sourced from the issue of commercial paper in the United States denominated in the United States dollars. So Justice Pagone agreed with Justice Robinson and said there's no reason to depart from John's conclusion that the hypothetical agreement might reasonably have been expected to be in Australian currency, but it wasn't as firm as Justice Robinson. This question of the currency was a key point that was in the Commissioner's Notice of Contention that Michael referred to before, there were hints that when I said before, the full federal court, my impression was they seemed more prepared to have a look at what was happening in the real world, what CFC was doing to inform its conclusion around what Capel would have done. So, so some interesting comments in there, but at the end of the day, the full federal court has agreed with Justice Robinson that whilst you might alter terms and conditions in a hypothetical world, you don't change the currency. There was enough said around FX risk and the rest to support the conclusion that Justice Robinson made at first instance. I think that sort of covers it, Michael?
No, I agree with that. That's a very good summary. The only comment I'd make is that it, again, once again highlights what we perceive as the problem that arises, that if His Honour Justice Pagone's counterfactual hypothetical is correct, then what does one do with the case of, in this, Chevron US going out to the market and borrowing in any currency for that matter, and on lending to its foreign subsidiary in the currency of account of the foreign subsidiary, which, as you recall, the trial judge found for good commercial reasons, the Australian subsidiary borrowed in $8. In fact, it was a refinancing of an $8 debt. So again, I think the court has created some very real issues for taxpayers going forward if the decision is, as His Honour Justice Pagone says, that, well, when you look at the facts of what happened at the raising of funds level in the United States, it's permissible to take that into account and say that that could be collapsed and that fundraising could be done at the Australian level. It seems to skate over entirely the reason why the trial judge found that it was an $8 borrowing and should have been an $8 borrowing between independent parties, and that was because of the FX risk. And it just everything skates over this issue, which seems to us to be quite a glaring omission. But His Honour said what he said, and that's on paper.
It may be, Michael, that the full federal court skated over it because Justice Robinson didn't really deal with that question of FX risk in any detail in his 206 pages. He mentioned it, but he didn't really explain in the decision, as I recall it, how the FX exposure arose.
That's true. Well, but he did it shorthand. He accepted the evidence of the relevant Chevron executives that the reasons why they borrowed in $8 was A, to refinance an $8 loan, and B, and more importantly, to avoid FX both in the accounts and tax purposes, where the FX swings on the principal could move either way.
If I could just chip in here with a question in relation to that issue on the foreign exchange and the functional currency point. Taking a bit of a step back, if the loan theoretically was US dollars and Capital would therefore potentially have a foreign exchange loss in its own accounts, and that was the reason, obviously, for one of the reasons why the court decided an $8 functional currency loan was probably appropriate. Would not CFC have also had a corresponding gain? So therefore, in its consolidated accounts, it would just be a wash.
Well, that's what the Commissioner argued. The Commissioner, Paul, I'm hesitating. Both Michael and I will hesitate because when we go into FX and the arguments that came up, we could spend another couple of hours on that. But you're quite right. This was meant. It was the subject of expert evidence. We had expert accountants opining on this. Chevron had them. The Commissioner had them. And that's what the Commissioner said. The Commissioner said, hold on a second, if Capital owns CFC, in Capital standalone parent account, yes, there would be an FX loss or exposure, but they net out in the consolidated accounts. At the end of the day, the consolidated accounts are more important than the parent company accounts. And then if you said we might suffer an Australian tax consequence on the paying side, on the capital side, that is, we don't have on the CFC side, well, the only way you're going to get a tax leakage on the paying side is if you have a gain on the paying side. And what does that mean? That means that instead of having a $100 gain, you have 70 cents in the dollar gain. Does that make sense?
Well,
anyway,
we are delving. The answer to your question is that for tax purposes, the FX gain or loss risk will there come what may, no matter who is the lender, and that could swing either way. Capital could have made a huge deduction, or could have made a huge gain, which would be taxable or deductible, as the case may be. But the accounting question, the evidence was slightly different in that, yes, the consolidated accounts would net out. There's no doubt about that. It was wholly owned subsidiary. But the fact of the matter was, especially in 2003, the ability of the holding company to pay dividends didn't depend on its consolidated accounts, it depended on its statutory entity accounts, which would be affected by the FX gain for accounting purposes. So that was the difference in the evidence. The Commissioner emphasising, as a matter of economic substance, the two cancelled out in consolidation accounts. But again, just to look for the principle first, forget for the moment the CFC and just look at CBX lending to Chevron Australia. At the end of the day, Chevron US is US dollar accounting, Chevron Australia is $8 accounting and $8 tax returns. The issue will arise every time, irrespective of the actual structure, and it kind of is a bit of a furphy to look at the CFC structure. Right.
we're getting a bit of a hurry along again for us, but Paul, I just want to say that we did have a slide in this pack which was two super tankers passing in the middle of the night, and on this one there was a bit of ships passing the night because the Commissioner focused a bit on the P&L statement, the impact on the P&L statement. Chevron focused a bit on the balance sheet and the debt on the balance sheet, the FX exposure of that. Anyway, enough said on that, just to move it along, and Michael and I not get into trouble for taking too long. We're on to topic 7, finding the arm's length consideration. And the good news is, I think we have covered on this point earlier on. At the end of the day, transfer pricing, like all tax litigation, is a matter of the onus of proof, and the taxpayer has the onus of proof. And the trial judge held, and the full federal court agreed that the taxpayer had not discharged its onus of proving that the consideration was not excessive. But the point made on this slide is we now have four judges deciding, 4 federal court judges deciding in favour of the Commissioner. We have 3 decisions, and this is one area where the decisions I don't think they fully align. So I think I referred to this earlier on, but in there you will see the paragraph references, and I think that reference of Justice Robinson might be paragraph 87 in the first instance, but I can't recall now. So I don't think I need to talk to that slide again because we referred to it earlier, and Heather, we just made up 5 minutes there.
And you can simply say that just simply is a reflection of their slightly different reasoning on the underlying point of what the consideration is.
So moving, one of the, this slide is in here because one of the biggest challenges in transfer pricing is finding comparables. And that is particularly prevalent in the context of big ticket cross-border financing. If we were dealing with motor vehicles or televisions or consumer goods or whatever, arguably it is not too hard to find a comparable. At the end of the day, a Mercedes is not that different to a BMW. But in the area of cross-border financing, the terms and conditions, the size of the fundraisings, the uses to which the funds are put, the creditworthiness of the borrower, gosh, it gets hard. And Chevron, I think, is famous in a sense for the fact that it was the longest hearing at first instance in tax history, as far as I know. So 5-week hearing. It involved 19 experts. 12 called by the commission, 12 called by Chevron, 7 called by the Commissioner. Many of them opining on the issue of comparables or what would have happened out in the hypothetical land, and all 19 experts being rejected in some shape or form, which time permitting we can come back to. The treatment of the experts, of course, was primarily the province of Justice Robinson, less said on them in the full federal court. But the we have up there a point post this full federal court decision. This is still a big challenge. It is just a big challenge. And there's a bullet point up there, where to from here, and that is going to be debated between taxpayers and their advisors for many years to come. So, Michael, did you want to say anything on that?
No,
yeah.
No, I agree.
So now, so we're moving to subdivision 815A, and most of the full federal court discussion is in relation to division 13, which in some respects is slightly disappointing because although both Division 13 and 815A were repealed at the same time at the end of June 2013, and today we have 815B, it's fair to say that 815A was a bit more like a prototype provision for the building of 815B. So comments on 815A are more likely to inform the interpretation of 815B than Division 13 would. but most of the analysis was on Division 13. The architecture of 815A is different to Division 13. When Division 13 is in the world of property and consideration, 815A is in the world of transfer pricing, benefit, conditions, and an amount of profits. We put in there the reference to conditions and the reference to an amount of profits because both of those got some airplay in this full federal court decision. So just dealing with those in order, the Commissioner identified 11 non-arm's length conditions which are set out in paragraph 582 of Justice Robertson's decision. And if you don't want to go and read 206 pages, they're repeated in paragraph 152 of the full federal court decision. Down on that slide gives you some examples, common ownership, the central role of Chevron Treasury, the lack of bargaining or negotiation between capital and CFC, the control of credit profiles, one party owning the other party. One party profiting from lending at a higher interest rate and taking back. All these conditions were raised, and the full federal court said, Justice Pagone said that the trial judge was permitted to take into consideration as conditions the relations between capital and CFC and of other members of the Chevron group. All those things could be taken account of. And he said the matters identified by His Honour, being the 11 conditions, may fairly be said to be conditions which existed between capital and CFC, which operated between them, which differed from those which might be expected to operate between independent parties dealing wholly independently with one another in respect of the loan. So on conditions, I think that is rather clear. There were various arguments put forward by Chevron in relation to this. I'll let Michael talk to those, but
I think they're almost statements of the obvious. I mean, at the end of the day, the conditions, the only question is which are conditions and which are commercial and financial relations, which is where the rubber hits the road.
Yeah.
If I may just ask a question with the 815A and its relevance to cases which no doubt possibly arise under 815B, are we saying that the analysis is in the full court decision useful, or is it yet to be considered in any great deal?
Okay, well, my answer to that would be both. It's yet to be considered, but it will be useful, particularly in circumstances where it's the only federal court decision dealing with 815A. It will inform, and I've seen there's been questions from a number of the people listening in on this around, well, can you confine this analysis, this decision to its own facts? Well, my answer on that is no. The principles that we are talking about here today are ones that are going to be applied and be quoted and have to be considered in future transfer pricing disputes. Whether they are in relation to pre-2013 fact patterns or even if they post-date and they're in the world of 815B. Of course, the terms will be different. There are various restrictions in 815A. We don't have there's a specific reconstruction provision in 815B that isn't there in 815A. 815A is only treaty jurisdictions and so on. So there will be key differences in the words, but they're cousin provisions, if you like. They're not identical twins.
Just not orphans.
Definitely not orphans. Michael, was anything you wanted to add to that?
Yeah, I wouldn't say it elucidates too much on 815, other than if anything,
815B.
815A for start doesn't seem to do much there to help sort of advisors, except it seems to err on the side of just about everything being a condition rather than a commercial and financial relation. The one thing that it doesn't go through in great detail, the judgment, is what I'll call the treaty issue. The 8150, of course, was an enactment of Article 9 as a taxing power. And if at the end of the day, whatever a court makes of the statutory provision 8150, it has to coincide with the understanding of how those terms are considered in the treaty, because that's where they come from, commercial and financial relations and conditions. And I think what needs now is to be a consideration, possibly at least at the full court level, if not higher, of just how one interprets those provisions in the treaty, because otherwise you'll have the treaty being a shield to a statutory provision which is supposed to reflect the treaty. Right.
Okay, well, we're coming now to there's another interesting aspect. So if you, with 815A, is you refer the architecture. Remember that the architecture of 815A is an entity has to get a transfer pricing benefit, and there are tests for that. So you've got to be an Australian resident. Then you've got to have the requirements of the Associated Enterprises article are met, and then you have, an amount of profits which, but for the conditions mentioned in the article, might have been expected to accrue, as by reason of those conditions not so accrued. And then D, had that amount of profit so accrued to the entity, the amount of the taxable income would be greater, in essence. That's the transfer pricing benefit. So a question comes up, and it's dealt with at the end of Justice Pagone's judgment and at the end of Chief Justice Allsop's judgment. Question comes up about how do these words interplay, and there's a bullet point there to say, well, is profits a net concept, or is it a parcel concept, if you like? And those words don't appear, I should say, in the decision. They're just a colloquial way of trying to explain what is going on here. So by net concept, I mean is to say, stand back. Taxable income, you have the taxable income. A taxable income is assessable income minus allowable deductions. You have the taxable income. The phrase here is an amount of profits. Why is this important? It's important because one of the arguments that Capital raised was, hold on a sec. We paid interest to CFC, but we brought that money back in the form of 23A dividends. That came into profits. It should be recognised profits, a reference to profits is not equivalent to a reference to taxable income. The profits at the end of the day, whether we paid a 200 million of interest or we paid 1 million of interest, and we brought it all back at profits, the same net position. So when you go through both Justice Pagone and Chief Justice Allsop's comments on this, a little bit clunky, but Pagone J said the focus of the provision is the tax effect of the dealing, not the overall income of the taxpayer. So the way I'm interpreting this is, and Chief Justice also said there is, however, no mandate or requirement to look at the profit position of capital only at year end. So I think what the judges are saying here, is that an amount of profits it's the parcel concept, if you like. It's not the net at the end of the day. So 815A refers to the taxable income, but it refers to an amount of profit. So it's not referring to the Pacific Ocean, it's referring to an ocean, whether it's the Pacific, the Atlantic, or whatever. And if you have an amount of profits that you can find has not been brought in by virtue of paying away too much, this requirement is satisfied. I think that's where they're going. Now, the Commissioner did put up an argument, and it was in the notice of contention, that profits equals taxable income. The court said, well, no. And the reason it did that was off the back of, I think it was Section 3.2 of the International Agreements Act suggested that's the case. And the court said no, but they got there by another means. It said an amount of profits is not the profit, it's not the profit at the end of the year. So they found that was satisfied, notwithstanding that the dividends are coming back. I don't think I've explained that very well, but I don't think the judge has explained it all that well either. So, Mike, I don't know. Did you want to add anything on that?
I agree that it's confusing. Interestingly, they seem to have rejected the Commissioner's assertion. Pagone says there is no basis in the text of the provisions or in the policy they express to equate the profits referred to with taxable income and taxpayers. So that's a pretty clear statement, I think. Yep. And the taxpayers' arguments were rejected by the Chief Justice on the one hand because he felt that you could not look at it on an annual basis, and in Justice Pagone's view that it's a bit like when you look at Part 4A and you want to disallow an interest deduction but allow a compensating adjustment. You disallow the entire tax benefit but look to what I call the rest in the compensating adjustment. And I think that is probably in line with his overall Part 4A approach to Division 13 and his reference to guaranteed fee, that he was thinking that to disallow the entire tax benefit, which is the excessive interest deduction, and if there's any adjustment to be made, then you look at it as a compensating adjustment. I will make one comment though that has always again bemused us, and this goes back to the court viewing the elephant in the judgment as being the tax avoidance purpose is, and it was raised in a question which I must admit until you explained it to me, Paul, I didn't understand, and I thank the person that sent through the question, and that is when you go back to the origin of our foreign tax system, and at the time most of these provisions were enacted, it was at a time when we had foreign dividends received by an Australian company were indeed accessible, but subject to a foreign tax credit, and it was only after the tax reform in the 90s that suddenly we had the concept of non-assessable, exempt income. And if this, for example, had occurred then on any view, the taxable income would never have changed. Right. And I think that's what, especially Justice Pagone, who is a man of great tax history, would understand that. That's why I think he was a bit, that he was reticent and indeed held to the contrary, that it's not a reference to taxable income, it's a reference to profits in the true sense. The difficult question for the taxpayers going forward is that what they basically said is, well, it's on the one view, you look at the hypothetical transaction to give you all these extra features, but when it comes time to comparing the profits under 815A, you don't look at the entirety of the transaction, which leads you to believe all these things. You only look at the actual interest deduction. And that seemed to us to actually be another example of the dangers of importing Part 4A into Division 13.
If someone back here, there's another question that's come through in relation to this very point, and it's dealing with the fact that it appears that the Chief Justice relies on a different subsection in relation to getting to what may be considered by some to be a convoluted result of this profits point by referring to, I'll get the section right.
15(1)(c).
I think Chief Justice refers to 1D, whereas Justice Pagone refers to 1C. And I think that the inference being, one is talking about accounting profit in the true sense of the word, but I think the inference being that the Chief Justice talks about that amount of profits, referring back effectively to the interest, the non-denial of interest deduction being that profit.
Yes.
And it seems to be that the difference of view as to how I suppose one may see a tortured result has been reached in relation to this issue.
Yes.
Any observations?
Well, the majority judgment is Pagone's judgment, and what His Honour said, presumably, stands as full court precedent on that point. It's one of the difficulties with understanding what influence on precedent the the comments of His Honour the Chief Justice carried them, because he said he did not want to be seen by way of qualification of Justice Pagone's reason.
Yeah.
So we're not quite sure exactly how you reconcile that.
Yeah. I don't think it'll be. I think there'll be more said on this and more analysis of that, because the views on this are really evolving. It wasn't something that got too much airplay at first instance. So,
but I understood Justice Pagone's comments on this point as a natural consequence of following through on a consequential adjustment for the guarantee fee.
Yeah. All right. Well, moving along, we're on to topic 9, and I don't think we need to spend a lot of time on this. But there were, of course, most people all know that there were 5 years in play in this Chevron case, all 5 years covered by Division 13, the last 3 years in question covered by Subdivision 815A. There were separate determinations made in relation to Division 13 and in relation to 815A, and separate assessment notices issued, and that raised questions about how they interact. And one of the arguments the capital put forward was that well, there can't be a transfer pricing benefit in terms of 81515 because Div 13 operated to deem the consideration for the loan to capital to be consideration for all the purposes of the application of the Tax Act. But that was held, and there was a fair bit of analysis on this. I think Justice Pagone likes this sort of stuff, but the essence of it is in that next quote you have on your slide. It's not uncommon to find different provisions being simultaneously operative to impose liability. Neither provision is excluded from concurrent operation to supporting one liability imposed by an assessment. So, so there was a fair bit of analysis on that is probably of more interest to lawyers than people in day-to-day practice. Mike, did you want to say anything?
No, I think what His Honour said was quite clear. There was a difference of opinion, obviously, in the submissions, but the court was quite clear on this.
Yeah. So, in the time that we've had for this webinar, we've not dealt with some of the topics here. Penalties. There's no comment on the full federal court on penalties. There was at first instance. There was a penalties. The old failure to take reasonable care penalty level of 25%. I couldn't see penalties being the next threshold is recklessness at 50%. I would have thought that would be a bit harsh. But there's no comment in the full federal court on penalties, so that's really just to note it here. There were comments about and a lot of discussion around the validity of the Division 13 determinations and the due making provisions in Section 177, which were repealed at 31 December, and new provisions brought in at 1 April. So we had this thing called the legislative lacuna that came up during the hearing that the lawyers hadn't cottoned on to, but one of the judges mentioned in passing, and that meant we all had to come back a week later to put submissions forward in relation to this legislative lacuna, which was a 3-month window, which would have or could have potentially had quite severe impact for the Commissioner in circumstances where the Division 13 determinations were made by somebody who didn't actually have the internal authority to make those determinations. Well, the decision was handed down on the 21st of April, which I think largely, Michael might differ, but largely sidesteps that issue. If it had come down on the 21st of March, it may have been a different story.
So that was an intentional decision by the court to delay the decision till after 1 April?
Was it? Yeah.
Well, the court, in fairness to the court, popped up on a pretty little last version of the appeal, right? And it did come up in a rather unusual way.
Yeah.
And counsel for the Commissioner notified the court of the problem. The court didn't know what to do with it and asked everyone to come back in a week with submissions. As it turned out, for those that aren't familiar with the provisions for dealing with appeals, when you have an appeal in the federal court on a tax matter, it is a rehearing and applies the law at the time of the appeal. Right. So if because of this gap in the legislation, 3 months, there was no section 177 to say the assessment, because of the error in the determination, then that potentially, not absolutely, but potentially would have meant that all the Division 13 assessments were invalid, simply as a technical point. And the court, though, would have had to hand down their orders, which is when the appeal ends, by the 1st of April. Right. And the court, even though they handed it down very quickly, the court indicated that they weren't in a position by the 1st of April, which was only, whatever it was, a month after the hearing to be able to come up with a view on that.
I'm just conscious of time. We're not going to deal, just move the constitutional challenge. There was a constitutional challenge to 8158. There are comments in the decision on that. You can read those yourselves. Part 4A, well, Part 4A, no, was not in play here, but clearly, and Michael referred to it before, there are some parallels to Part 4A analysis coming through in the world of transfer pricing now, where if you're going to price a loan that might reasonably be expected to have occurred, there is what am I trying to say? The DNA of transfer pricing and the DNA of Part 4A may be closer than people had traditionally thought. I think there's an implication coming through from this full federal court decision.
If I may ask a question there, maybe I'll direct it to Chris. Reading between the lines, you get the feeling, well, I get the feeling anyway, reading between the lines, that the full federal court was surprised that the ATO didn't argue Part 4A originally, and that sort of almost permeates the decision. Was there anything in the course of the hearing where that that vibe bubble to the surface? I've
been asked this question hundreds of times, and there are different schools of thought, and I have to say I've got different answers from different people, both within and outside the ATO. There is a school of thought, and there has been a school of thought within the ATO that if something is the natural domain of transfer pricing, then it should be tested under the transfer pricing provisions, because it's not appropriate for Part 4A to come in as a big stick overlay and potentially neuter the result that would otherwise come up for transfer pricing. And there's some merit to that. Otherwise, you have the general provision surpassing, neutering the result of the transfer pricing provisions. Others might say, gosh, on a matter and a structure like this, if it were replayed, would you bring both transfer pricing and Part 4A to the court? Well, maybe. You might recall there's been, unlike transfer pricing, there's a whole host of Part 4A decisions. At the time this decision came up, the Commissioner had a number of losses on Part 4A matters, in seeing RCI, Mongoose. Anyway, to a certain sense, it's all academic because it wasn't raised, and I like the idea that the best answer, I think, is that this is a transfer pricing case. It should test the transfer pricing provisions, and if Part 4A was raised, then what does that do for the transfer pricing provisions that needed, frankly, needed some judicial clarity, and that is why this case has been so much interest. Does that answer the question, Paul?
It does.
What needs to that's a rhetorical question. I'm conscious of time, so if you look at the next slide, you just see we put a bit of the current tax landscape is a very interesting one. The Chevron decision got a lot of airplay for a tax case. It got a lot of airplay internationally. I've had people sending me press and articles from overseas. Who would have thought? we live, on topic 12, we live in an interesting world at the moment. All these developments coming through in recent times. It was a bit cute to put in there. Some of you might have seen that the Commissioner's term was extended a week after the Chevron decision came out from 2019 to 2024, and the Treasurer said how pleased he was with the Commissioner getting this decision to full federal court. Interesting times. Diverted profits tax, a lot of work, a lot of interest in that. Corporate inquiry into corporate tax law is ongoing. And I thought this quote, closing with this quote from the Treasurer in another press release a couple of days ago, he said, Australia now has some of the toughest laws in the world to combat multinational tax avoidance, and a special dedicated task force within the Australian Taxation Office is reaping the results. And then that, I did get asked for breaching copyright, putting that last cartoon up there on questions, but it's off the internet, so I don't think we are. And we did have some other cartoons in there that Michael rightly pointed out we should take out of the slide pack, so we did. So we, Michael, was there anything to add on?
Just on the go-forward basis, on the assumption that the decision now becomes the law, that it's the full federal court, and is not in any way challenged in the future. Going forward, the real issue now is it appears that the court has sanctioned an application of transfer pricing provisions, which are obviously supposed to reflect the OECD guidelines, leaving aside or getting up to the point of what I call unilateral BEPS treatment. Excuse me. And the treaty reflect the OECD guidelines language, is we now have the arm's length principle in transfer pricing, or finance at least, determined on the basis of, excuse me, a decision which says that the borrowing capacity and the pricing of the debt taken on by an Australian subsidiary of a foreign multinational is in effect determined by the parent balance sheet. And my observations of the administration of the law after that is the message that's been carried forward by the tax office. For those who think that that is not the arm's length principle under OECD guidelines, if the full court decision is correct in this sense, and stands for that proposition, then there will ultimately have to be a treaty challenge to that to determine whether or not the domestic provisions actually, by invoking the complete counterfactual approach, override what at least some of us thought were the OECD guidelines. Now, I know there are others who say, no, this is just simply a case of everything's decided on its facts and we've got 23 AJ dividends, etc. But again, I don't think that stands up to analysis in the go-forward position. I mean, at the end of the day, all of Chevron's income is subject to tax in the United States. And the reason why pathway wasn't applied in this case is when you think about it, the counterfactual, if it be US dollars, trial judge found that independent parties would have borrowed in $8. It's finding a fact. So of the two components of the interest rate, in this case, one relates to the currency base, $8 BSW versus US LIBOR, and the credit risk margin. And there's not a lot in Part 4A when you consider all the factors to actually say that the pathway would apply, other than to determine a different margin for the credit risk. So on a go-forward basis, it does present some very interesting problems for how will foreign multinationals respond to this in situations where on any case, for example, US multinationals don't pay tax on the interest that they receive from their foreign subsidiaries because they're taxed on the income of that subsidiary. So, and the issue will pop up, for example, in the United States, where whatever the tax paid here is, the US will have to accept that will have to find that's an acceptable amount of tax paid in Australia and consistent with their views of the OECD guidelines, because they'll be asked to give foreign tax credits for it.
Just picking up that point, obviously the US is quite unique, being a foreign tax credit system regime, and it may change with the announcements of Mr. Trump in recent days. The analysis of say, a UK Australian interest rate arbitrage case, interest transfer pricing case, and we just face an exemption provision. Would the same sort of thinking apply there, do you feel?
Well, it comes back to the relevance of the foreign tax position to the determination of whether or not either part pro or the transfer pricing provisions by hypothetical should apply. The thrust of the complaint against multinationals expressed in the non-technical view is that Australia is a high tax jurisdiction and pays interest to low or no tax jurisdiction. Well, the UK is a tax haven now, according to our laws. It's 20% tax rate. So interest paid to the UK theoretically has to pass the economic substance test on the deferred profits tax because it won't pass the foreign tax liability test. So all these issues now are going to come out as to how it interacts. There'll be many countries around the world that have a lower tax rate than us, or give exemptions or participations, or foreign tax exemptions, or foreign income exemptions, I should say. And I suppose that now has, would appear at least on the face of it, to become a tenet of our law.
Another question that has been raised by the participants is obviously around the guarantee fee, and maybe I can address this to Chris. It appears that both the Chief Justice and the Justice rely very heavily on the fact there was no evidence to suggest that a guarantee fee should have been charged in the circumstance of the case. If there was, what's the feeling of the outcome?
Oh, if there was, we could well have had a different outcome. It's actually one point I didn't, and I should have made when we were doing that present, that there are a lot of references to the evidence, or more accurately to the lack of evidence throughout the full federal court decision. So you'll see it, for example, references to the need for evidence in paragraphs 18, 60, 127, 133. It permeates through both Justice Pagone and Chief Justice Allsop's decision. This is an area where the people on this call need to think about what is the evidence that supports getting an outcome. It won't just be that technically the position is X. There is the issue of proving it. So in the Chevron case, there was not a lot of discussion by both Chevron and the Commissioner around the topic of guarantees and guarantee fees at first instance in that 5-week hearing. But it came up. It was actually mentioned in the Commissioner's notice of contention that its alternative was that there would have been a guarantee. My perception at the hearing was that the Chief Justice was very interested in the topic of guarantees and guarantee fees, and that's come through in his decision. So I think if there had been evidence on that, I think I said in the presentation, my view, and I don't know if the Commissioner's view, is that if you go into a hypothetical transaction and you say there should be there would have been a guarantee provided, then it's conceivable that on an independent basis, an independent party providing a guarantee to a borrower would expect to some form of compensation or consideration for that guarantee. That then takes you into the area of the GE Canada case, and how much How much does it cost to give a guarantee to somebody? And you need evidence to support that.
The one problem you have, though, is that under 815A, at least, depending on which way you read what appear to be conflicting views on profits, it wouldn't make any difference to the case. It would always have to be a consequential adjustment, right, on one view, because they say the interest deduction, and you disallow the gross excessive amount. Right. Now, certainly that would appear to be the natural reading of Justice Pagone JJ, which of course carries the court. The chief which referred to taxable income, you may or may not be able to sneak it back in because it can be tax deductible. The taxable income may not change. But on a natural reading of Justice Pagone, that it had to be, it wouldn't have affected the outcome. It had to be a consequential adjustment.
One question that has come through in relation to the counterfactual in terms of the hypothetical position is whether or not the counterfactual, or does the court tell us or give any guidance as to whether the counterfactual is objectively or subjectively determined?
I would have said objectively determined. They don't talk in those. Sorry, no. Let's go back to I don't think it does really. It doesn't. It talks about the world of your commercial reality. It talks about not being pedantic. It talks about being flexible. One would have thought if you go into that's a good question actually. If you go into the world of commercial reality, the way you do that is to say, well, what happens in the real world? To accurately assess what happens in the real world, you would need objective, provable criteria. The subjective world of, well, we think we would have done it this way, probably would not cut it.
Yes, they don't sort of talk about it in those terms.
No.
And perhaps something may turn on in a particular case, but I think it's fair to draw from it that the language, especially of Justice Pagone's reasons, and thus the courts, is that you determine the reasonable hypothesis by reference to the evidence, and the evidence will be the evidence. Right. Now, whether or not they take into account what a particular person believed, even if it's not correct, may be relevant. They don't, as Chris said, they don't specifically address that conundrum, which has been specifically addressed in obviously the Park case.
Yeah. That's a good question.
Well, obviously maybe I'll address this question to Michael, and this is the question is in your opinion, Michael, not necessarily the opinion of your client. Will Chevron appeal to the High Court?
Very well put, but I can't possibly tell it. Now, look, as always happens, when you get a judgment of the full court, you have to analyse it very carefully. We are then discussing it with obviously our legal team. That's both the client's legal team and us. And then recommendations are made, and then the client makes a decision as to whether or not it will file an appeal or not. And at this stage, me disclosing what I think might transgress legal professional practice.
It was a good try, though.
And what?
Maybe a similar question. I'll address this one to Chris. Obviously, at this stage, obviously Chevron has lost their appeal, but the ATO had their own appeals. It's a point of appeal. And it's not clear if the full federal court rules on the ATO's position. I think the question may be directed to the functional currency question.
Okay. Well, the ATO didn't appeal. The ATO lodged a notice of contention. It's something less than appeal. The ATO didn't need to appeal because it won at the first instance, but it did put in a notice of contention, and the notice of contention to say, look, we're not cross-appealing the decision, but we do think these are matters where the judge got it wrong, for want of a better word. And in those areas, the first one was the currency point, the AUD-USD matter we've discussed previously. So the Commissioner is of the view that if the hypothetical transaction would have been for USD 2.5 billion, not the AUD equivalent. And that's not something that the court, either at first instance or on appeal, is confirming. But the other point which did not get addressed on appeal was the Commissioner raised in his notice of contention that there was an $800 million shortfall. Now this shortfall arose because the facility was entered into in late 2002 when the AUD-USD was a certain rate, and then by the time of drawdown in June 2003, the AUD had strengthened quite considerably, which meant USD 2.5 million didn't give what it was meant to give. There was $800 million that was short, that was unfunded, and so the notice of contention the Commissioner put on said that the trial judge failed to take sufficient account of that, and nor did Chevron's banking experts, Mr. Brose and Mr. Martin, adequately address that, in that they made an incorrect assumption that the amount of US dollars available would have been sufficient to discharge all of Capital's outstanding debt at the time, and it wasn't because of the movement in FX rates between date of facility and date of drawdown.
Good afternoon, gentlemen. I might need to just step in there, conscious of the time, and I do appreciate that all of you have hung around past our 90-minute scheduled session, but we are going to have to draw a line under it there, and any questions that remain unanswered at the end of this session, we will address those offline and respond to them via email. So all that remains for me to contribute this session this afternoon is to thank our presenters, Chris, Michael and Paul, for their input and their contribution this afternoon. If any of you have any questions or you'd like to follow things up with us, the contact information is on your screen now. And if I could ask you just to take a moment as you leave the webinar to complete the exit survey, that simply helps us get some feedback on how we did today.